to see you. Good to see you.
All rise. The Honorables, the presiding chief judge, the judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Dillon, and I'll be presiding today. To my right is Judge Michael Stadding, and to my left is Judge Carolyn Thompson. And we have one case on our calendar, State v. Dawson. And if the appellant is ready, let us know if you want to reserve any time.
Yes.
Thank you all for being here.
May it please the court. My name is Amanda Zimmer. I'm an assistant appellate defender, and I represent William Dawson. I'd like to reserve 10 minutes for rebuttal. Mr. Dawson raised one issue in this case: whether the trial court abused its discretion by recommending that his life without parole sentence not be altered without making any findings of fact or giving any reasoning for that recommendation. The state raised one issue in response: whether Mr. Dawson could appeal from that recommendation. I plan to discuss the issue from Mr. Dawson's brief and then discuss why he has the right to appeal. Before I turn to the issue, I'd like to just briefly start by talking a little bit about North Carolina General Statute 15A-1380.5. This statute was enacted as part of the legislation that, for the first time in North Carolina, allowed for a sentence of life without parole, a sentence that meant that the defendant would die in prison and never have the opportunity to be released. It stated that after the defendant had served 25 years of a life without parole sentence.
Let me ask you a question. Before the statute was passed, was there always the right to go petition the governor for reduction of the sentence? Or
Yes, Your Honor, there was
they could always do that. So,
yes,
okay.
always the right to clemency from the governor. But before 1994, any sentence of life carried with it the possibility of parole. In 1994, this package of legislation was enacted that included altering a sentence for a Class A offense to life without parole, meaning that the defendant would die in prison. And it included this statute, which allowed for review after 25 years by the presiding judge in the county in which the defendant had been convicted. And the judge was required to recommend whether or not the sentence should be altered or commuted. This only applies to to those sentenced for offenses which occurred on or after October 1st, 1994, and before December 1st, 1998, when 1380.5 was repealed. Mr. Dawson has now served over 25 years for a killing that occurred in 1997. He is 86 years old. After reviewing Mr. Dawson's sentence under 15A 1380.5, and without giving any reasonings related to the review, Judge Wiley recommended that Mr. Dawson's sentence not be altered.
Where does the statute require him to do so? The judge to make findings of fact of what he reviewed.
The statute does not explicitly require findings of fact.
So then how has the court not complied with the statute based upon the order that we have before us?
Based upon the purpose of the statute, in order to effectuate meaningful appellate review, it would contend that the factual findings are required even though the statute does not explicitly require them.
So assuming we have jurisdiction to consider the appeal, you're saying that we can't really conduct a meaningful appeal unless we know what the trial court judge found?
Yes.
Okay, that's sort of your argument.
Right. And this is not unusual that the court would require factual findings and some reasoning to be in order to conduct meaningful appellate review under the abuse of discretion standard. That is...
But you would agree that the legislature has always had the ability to make the requirement in its statute itself. If it required the judge to talk about what he or she found, then the statute would say so, and it's silent. Would you agree?
I understand that the statute is silent, but in addition to what the legislature says, we also have some basics of due process that apply to any statute that the legislature enacts.
Well, let's talk about this statute, because I'm thinking of the statute of like which parent gets the child, and there's an abuse of discretion, but there's a standard in the statute. What's the best interest of the child? Is there any standard that this judge, in exercising his or her discretion, is there any standard by which the judge should consider if it meets this thing, the best interest of the child or whatever, you should recommend clemency or whatever? Or is it just silent? Or is there no standard, in this
There's no standard set out in the statute, and I will say that the statute is not a model of clarity, and it was passed, back in 1994, 25 years ago, and now we're having to sort of grapple with what the legislature intended when it did this, and before it repealed it 4 years later. So I would say that there are a number of statutes that we have where this court has required some minimum factual findings and reasoning be offered, even in the absence of an explicit requirement.
Do you know is there any law on what the purpose of the statute was? Because the judge has no authority to do anything except simply to make a recommendation to the governor that the governor otherwise has the authority to do anyway. So the governor could, even if this judge said, I don't recommend it, the governor could still go and grant clemency. I mean, they're not bound by anything. Do we have any idea what the purpose of it or not really?
Yes, Your Honor. I believe we don't have anything explicit regarding the purpose. Our Supreme Court has hinted that the reason for this was to steer cases towards clemency that might be appropriate. The School of Government commentary on the statute has likewise said that the purpose of the statute was to steer cases that would be appropriate to the governor for clemency. but we do not have an explicit statement from the legislature
Okay.
that I've found.
That's fair, that's fair.
But we do know that some minimal due process has to apply to a clemency proceeding. Our Supreme Court recognized that in Bacon versus Lee. The United States Supreme Court has recognized that. And the question
I'm
that's
sorry.
raised by...
Excuse me, Counselor, I'm sorry. So if the statute in part reads shall, and then it gives the judge another prong of may also consider these things, aren't you then asking the judge to make findings of fact based upon evidentiary review rather than comply with the statute? I mean, to say, well, we find the following because we looked at the exhibits from court and found that it was not enough evidence to convict, doesn't that require opening up a can of worms of just going back into an evidentiary review?
No, Your Honor, I don't think that it does. The statute requires that the judge consider the trial record.
And that, in this case, the order says, I considered the record. How is that not complying?
I'm not saying that he didn't comply with the statute by not considering the trial record. I'm saying he needed to make some findings and give some reasoning, because what we know is that there's evidence, like you said, the trial record includes all the evidence, not just the version that the jury ultimately based its conclusion on to find Mr. Dawson guilty. It also includes, in my opinion, since once again trial record is not even defined in the statute, it includes all of Mr. Dawson's pro se filings, in which he apologizes to the family, in which he, again, asserts that it was self-defense. But the judge here also said he considered a number of things that the statute gave him discretion to consider. And there's some contradictions between what the family of the victim wrote in their letters and what Mr. Dawson wrote in his pro se filings and what he wrote, what his family members wrote. And we don't know what, if anything, the judge took to be true in this record.
Let's assume the judge believed everything the victim's family said. Believed it all. So explain to me the prejudice, because again, you don't have this best interest of the child standard type, parallel. So let's just assume that the judge had found everything. Would it still have been what universe, based on what was before the judge, could the judge have abused his discretion in making the determination? I clearly think it would have been abuse of discretion if the judge says, I'm not going to consider the court record because the statute requires the judge to do that. So tell me, assuming that findings have to be made, tell me how there was prejudice. Because let's assume the judge found everything. I find all this other stuff. I just still don't think that this person should get out of jail.
Right, I understand. And the prejudice here is that without...
Or I believe everything the defendant said. Let's say believe everything the defendant said or whatever.
Right, without any reasoning from the judge or any findings regarding what he found credible or what he didn't find credible, Mr. Dawson has no way to increase his chances the next time this case has to be reviewed. And the statute does entitle him to a review every 2 years after the initial review. So the prejudice is that he cannot increase his odds of having a favorable recommendation without knowing what the judge considered and what he found credible and what he didn't find credible. If, for example, the judge found it credible that Mr. Dawson had not expressed remorse to the victim's family as the victim's family believes, and not as Mr. Dawson has said in his pro se filings and as his family believes, he can't take any action to try to remedy that without having any information from the judge about the weight that the judge attached to that. So the prejudice is that this is going to be reviewed again, perhaps by a different judge, and it would be part of, I think, the trial record, what the original recommendation would be. So I think the prejudice here is that the statute's purpose in allowing for continued reviews just can't be met if the defendant doesn't have any information about what he can do to change the outcome. And again, I'm not asking for a lot here. A simple statement, such as those contained in the denial of Mr. Dawson's pro se filings, just explaining what the judge found to be significant and the reason why he felt that alteration of the sentence was not appropriate. And here we're just left guessing. So we don't know what the judge considered. He says he considered these things, but we don't know the weight. We don't know why he reached the decision that he did. And that makes it nearly impossible for this court to allow to meaningfully review what happened, and it doesn't help the governor.
What if the trial court found, I don't believe this guy that he's got remorse. 2 years from now, it's before another Supreme Court judge. Could that judge make an opposite finding if they wanted to?
Yes, I believe they could.
Okay, so you don't think, because okay,
Yeah.
which is fine. I mean,
Again,
that's fair.
unfortunately, the statute's not very clear.
Because he could have it heard in 2025 by anybody I guess any resident Superior Court judge down in Craven County, I guess.
Right.
Doesn't have to be the same judge.
It has to be the resident Superior Court judge, and as you know, they change, so it
Is
could.
there just one resident Superior Court judge?
I'm sorry?
How many resident Superior Court judges are there in Craven County? Because I have no idea.
I'm not sure.
Okay, that's fine.
But I do think it has to be the senior resident.
I think it just says a resident.
A resident?
The statute says a resident Superior Court judge is what it says, but the statute that y'all cited, that you quoted. But a resident Superior Court judge for the county in which the defendant was convicted.
What you're asking today, is that more of a legislative request than a judicial request?
No, Your Honor, I don't believe it is. This court's responsibility is to interpret the statutes and ensure that they comply with minimal amounts of due process. And when the statute is unclear and we have a standard that some basic requirement of due process has to apply, then I think it is this court's job to say what that process is.
And you don't think it was minimal here? I mean, the order reads in part, I have reviewed the record, I have considered the following. Those were the minimal that you just cited.
I agree that the court did provide some minimum process. I think the process that was due here is notice that the review is taking place, an opportunity to be heard, and the reasons for a denial. And I'm taking that from some of the minimum process that occurs in clemency, where our court and the United States Supreme Court have recognized that you have to give someone notice and opportunity, and from the Fourth Circuit's decision in Van, which discusses the minimums for parole, which is saying that you have to give somebody notice of why they're being denied. And that's traditionally done with parole in this state. They are given a reason why they have been denied parole, because they're going to come back up, and then a defendant can have the chance to improve their odds the next time.
What kind of finding would the judge make that you would consider would be an abuse of discretion? So I'm still trying to get to the prejudice. So so I'm still saying if the judge found, I guess if the judge found that I think he really did do it in self-defense, and I don't think that, maybe, but I don't know. But what kind of finding could the judge have made here that you would think it would be an abuse of discretion for the judge not to grant clemency or recommend clemency?
I think that had the judge reasoned that Mr. Dawson has been a particular danger in prison, and he shouldn't be allowed to be released, that would be an abuse of discretion.
What if he says, I don't think he's a danger in prison? I think he's a model prisoner. I just don't, in my discretion, I just still think justice is better served if this guy serves his sentence. I mean, would that be an abuse of discretion? Is this statute intended to say if you're a model citizen for 25 years, you automatically get out, or can the judge still exercise discretion and say, I still just don't think, because you got life imprisonment without parole, and even though I think this person's a model citizen and has acted great, I still just think in my discretion. Would that be an abuse of discretion to make those findings?
I think that would be an abuse of discretion. I think that would be arbitrary. A different judge could look at the same record and say the opposite, and that's
what abuse of discretion is. I mean, child custody cases, you got the exact same findings. I could say, I just think the father's attributes are better, and the other judge could say the mother. That's what abuse is. It's not, because human decision-making can be arbitrary, because you and I could disagree on things, and we go, it could be reasonable. So I don't know if that's good enough. I mean, I'm just trying to think. So, but you're saying it would, so you're setting a standard. If you, best interest of the child, model citizen, it's abuse of discretion in terms of what you make in the findings, but if you find this person's a model citizen, you have to let them go. Is that the standard?
That's not what I'm saying. I don't think that's there.
So why would that be an abuse of discretion? I'm trying to think. So even if the judge had found this guy was a model prisoner, why would that have been
Well, I would say that would not be a just and reasoned decision supported by the finding that he made. If someone is a model prisoner and they're no longer a danger, what is the reason to keep them incarcerated?
Justice, because it was just. I mean,
and
we can disagree on what justice is. Is that a fair sentence? I don't know.
And I would also say that the statute allows for alteration or commutation. And that could mean that what the judge says is, I don't think this guy is ready to be released, even though he is a model prisoner. I think the just thing here is to alter his sentence to allow for the possibility of parole. And then the defendant still has to go before the parole board and prove that he's worthy of parole. Maybe he's denied. We don't know. But that would be, in my opinion, not an abuse of discretion to say, the sentence is now altered to life with parole, but I'm not ready to say this, I recommend that his sentence be commuted. But I do recommend that his sentence should be changed to allow for the possibility, because he has taken steps towards rehabilitation, and he has shown that he's no longer a danger. And I think that would be appropriate and not an abuse.
Why is this an argument you would make at the trial court level? Because, I mean, in my discretion, I might totally agree with you. I might think this guy's 85, 86 years old, and there's probably a lot of judges that might agree with you. But, you know, but it's an abuse of discretion. It's just, as it is in a lot of cases in the state, it's whatever judge you draw in a domestic case or whatever. So I'm just still trying to think. So you think, though, there is some type of standard which, like, best interest of the child, that it would be an abuse of discretion not to let the person go if you made certain findings? It would just be a total abuse of discretion.
I think the abuse of discretion standards apply, and that means this court reviews to make sure it's not arbitrary, to make sure that it's reasoned, and that it considers the circumstances and the law towards a just result. What we can't tell from this order is what reasons the judge relied on, what he weighed, what facts he found. We don't know. And that means that when you're looking at it, Your Honor, you can't tell how he exercised his discretion. To me, that is an abuse of discretion to not enter an order that complies with those minimum due process that sets out factual findings.
Are there other cases that say that? Because I know there's a lot of types of orders where we review for abuse of discretion. Can you point to a case where maybe the statute doesn't specifically make a requirement, you make findings of facts, but there's a requirement that we be able to figure out what the judge was thinking, and we send it back for findings?
Yeah, I think in my brief I cited Allen versus Rupard from this court.
What's the site?
It is 100 NC App 490 at 495, and that's a 1990 case. And I believe that case is an example of where factual findings were required in the judge's order beyond the language of the statute. And the state pointed out in its brief, State versus Jones, which dealt with our mistrial statute, and how in 1997 the legislature amended that statute to explicitly require findings. But even before that explicit requirement, there was some requirement as far as...
Was our court's reasoning in that 1990 case, it was because we can't tell, we can't adequately review whether this judge abused his discretion or not because we can't see what they were thinking? Is that what the reason in 1990?
I'm sorry, excuse me.
Which, if that's true, you would say that would hold over here too, because it seems like your argument is there's no way for us to tell if this judge abused his discretion or not because we don't know what he was thinking. And we're not saying he did or didn't, but he needs to make findings so we can adequately review it.
Right.
Assuming your client's entitled to an appeal.
Right. In Allen, part of the reasoning was that the findings of fact and conclusions of law were insufficient to allow for meaningful review of the distribution of a settlement proceed between an insured employer and the employee. And the court said that there wasn't sufficient findings related to that distribution, and that this court wasn't able to review it, so it did remand, I believe.
Okay, I'll go.
So cases like that show that sometimes the court does require more than the statute explicitly says. And
you got about a minute before you eat into your 10.
With that in mind, then, I'm just going to reiterate that I think that in order for the statute to have any effect or for there to be meaningful appellate review, there needed to be factual findings that supported the reasons, that support the conclusion that the sentence here, that resulted in a recommendation that the sentence not be altered. I just want to briefly touch on the idea that Mr. Dawson doesn't have a right to appeal, and I would just say that subsection F of 1380.5 explicitly sets out a standard of review for appeal in this court or the Supreme Court as abuse of discretion, and that statute would have little meaning if Mr. Dawson did not have a right to review. I believe 7A-27 gives him that right, if 15A-1444 does not. This was a final judgment. It resolved all issues between the parties related to this review, and it is appealable. So I'd ask that this court recognize that Mr. Dawson has a right to appeal, vacate Judge Riley's recommendation, and remand for new review under 15A-1380.5. And I'll reserve my remaining time.
Thank you so much.
May it please the court, I am Robert Montgomery, and I represent the state of North Carolina in this case. At the outset, I wanted to comment on the fact the defendant has very well covered the process here, that there was life with parole, and then in 1994 there became life without the possibility of parole, and then this statute was repealed, 15A 1380.5. It is important to realize that in that 4-year window, there were about somewhere over 200 defendants who were sentenced to life without the possibility of parole, for whom this statute applies. And so those are either eligible now for review or soon will be eligible for review. And defendant here has asked this court to write something new into this statute. And it should not do that because the statute plainly does not contain that requirement, and because our Supreme Court has already made clear that there's nothing close to parole in this case as far as what the trial judge does. Now, there may be an element for the parole commission, but as far as what the trial judge here does, this is not the same thing as parole. And the court in State v. Young made that clear. But if I may, I would...
But a trial court judge could abuse his discretion in carrying out his or her duty under the statute, because the statute says review for abuse of discretion. So the legislature contemplates there's some way that the trial court judge could abuse his discretion. Isn't that true?
Absolutely.
So how could a trial court judge abuse his discretion in denying somebody clemency? What universe would that, what do you think?
Well, first of all, it's not denying clemency. It's just making a recommendation. But yes, there could be, absolutely, there could be an abuse of discretion, and it could work this way. If the trial judge did not follow the requirements of this statute, or perhaps the trial judge said, I'm not going to review this, or perhaps, as in the Bacon v. Lee case, which defendant cited in talking about clemency, it said that there are minimal due process requirements to clemency, but as far as abuse of discretion, that would be like someone flipping a coin to determine yes or no. So if it were truly arbitrary...
We're not reviewing the record when the statute
Correct.
says
If it were
shall.
truly arbitrary, it's not that arbitrary and a reasoned decision. What this court said about abuse of discretion is there's an abuse of discretion when the ruling is manifestly unsupported by reason or is so arbitrary that it could not have been the result of a reasoned decision.
So the trial court judge could find, I think it's a model prisoner, blah, 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 but I just think in the interest of justice, this person, my recommendation is the person stay in jail, and that would not be an abuse of discretion.
Yes, if the court made those kinds of findings, but the statute does not require any kind of findings at all. In fact, the statute does not require an order. There's nothing in the statute that says there has to be an
Well, let's say the judge says, I'm not going to make a recommendation. How can we review whether or not the judge actually reviewed the court file? Because that would be an abuse of discretion. We can't conduct meaningful review unless we know whether the trial court judge did that. So if the order simply said, in my discretion, I deny, I choose not to make a recommendation, I would think, would you tell us that we shouldn't be able to at least send it back and say, make some findings. Did you consider the record? Because I can't tell whether he reviewed the record. Because you would say if he didn't review the record, that would be an abuse of discretion, because the
Yes,
statute requires it.
if the
So
judge
how
did
would
not-
I know whether he reviewed the discretion without some findings, whether he did or not? So would you concede there at least has to be some findings such that we can make at least a meaningful review of whether or not he abused his discretion?
There has to be some showing that there was compliance with the statute, and whatever the
So
way
you
that would...
can see there's going to be some kind of findings, or
That would seem,
something.
that part of it, yes, but
Okay, that's
other
fine.
than that, there's no other requirement except that the
Well, there's no
court...
statutory requirement that he makes any findings. It's just for us to conduct
Right.
meaningful review. We require findings so we can make sure, I mean, to be fair, I would think.
Yes, the statute requires the trial judge to do two things: review the trial record and make a recommendation. That's what the statute requires, and there's nothing else. There's no requirement of an order. There's no requirement of findings of fact, although it would be important to know that...
Do they have the right to appeal it?
Well, that was the first issue I was actually going to cover, because if we don't get past that point,
Let's
you
talk about
don't
that
need
for
to
a
worry
minute. We'll talk
about
that.
anything else.
If they have the right to appeal it, then we got to have findings to have a meaningful review, I would think. At least a finding to say that I reviewed the record. clearly, I would think.
That's the most that
That's fine, I
would
mean,
be
it's fair.
required.
But so talk about the right to appeal.
Well, defendant has conceded that 15A 1380.5 itself does not state that there is a right to appeal.
Well, she says that, I think it's mischaracterization. She said F says, it assumes that, because it says, it talks about the recommendation of the judge made in accordance with the section may be reviewed on appeal only for an abuse of discretion, and by implication, I think she's saying that assumes there's a right to an appeal. I don't know, I mean.
Yes, defendant said that assumes there's a right to appeal, but that's different from saying that that statute itself gives a right to appeal. Defendant's position is that 7A 27 is the statute that gives the defendant the right to appeal. No one, either in this case or in Young, the case that the North Carolina Supreme Court decided, ever has said that the statute itself gives a right to appeal. It does give a standard of review, which would seem to contemplate some kind of review. But 7A 27, in Brown, this court made very clear that 7A 27, when it says final judgment, it means a judgment with a sentence. That is the final judgment from which a defendant in a criminal case may appeal, is when the sentence is pronounced by the trial court. That is what 7A 27 means. Defendant cannot get around that. Defendant may not like Brown, but that is what Brown says. And that should apply here just as it applied in Brown. Of course, Brown was dealing with a different statute. It was dealing with 15A 269 and 15A 270. But the issue,
What are those statutes?
those involve DNA testing, post-conviction DNA
So
testing.
if a defendant asks for post-DNA testing and the judge denies that request,
Correct.
they have no right to appeal.
They do now, but only because after Brown was decided, the General Assembly enacted a statute that gave them that right to appeal. And in fact, after the Brown decision was after 15A 1380.5 was passed. The legislature certainly could have gone back here just as it did in Brown and give these defendants, these 200-plus defendants, a right to appeal every 2 years when they got their review. But the legislature has not done that. And so there is no right to appeal. To the extent that 15A 1380.5 talks about the standard and seems to contemplate some kind of review, appellate review is not limited to a direct appeal. If you look at 15A 101, which is a statute that gives definitions, it says that appeal, when used in the statutes, includes petitions for writ of certiorari or review by writ of certiorari. So it could well be that that is the kind of review that could be obtained in these cases, is review by writ of certiorari. But there very clearly, there's nothing in 15A 1380.5 that says there's a right to appeal. Defendant has said that himself. And in fact, although it sounded a little different today, in some of the filings, defendant said 15A 1444 also clearly does not give a right to appeal and has hinged everything on 7A 27. And Brown says defendant loses on that point. This appeal should be dismissed. Again, there may be other ways that there can be appellate review of an order that is entered by the trial court.
We could just grant cert on our own if we want to and review this.
That is correct. Under Rule 2, you certainly could do that here. The state
Why would
would...
we have to implement Rule 2? 7A 32 says we can on our own grant rid of, what rule are we violating?
Correct. No, there's no violation. You could treat...
I don't think it's a Rule 2 violation. I don't think we have to.
No, I think that's right. You could certainly treat this appeal as a petition for certiorari. Defendant has not filed a petition for certiorari
We can do it on our
in
own
this case.
if we want to.
But you can do it on your own, but the state would say, don't do it, because there's not merit to it. Just like any petition for cert, if this court wants to treat it as a petition for cert, it can do so, but petitions for cert still should only be allowed under certain circumstances, including looking at the merit. And there is no merit to this appeal. The trial judge did everything the trial judge was required to do, and there's nothing further necessary. And in Young, the North Carolina Supreme Court made clear that there was essentially unguided discretion for the trial judge in this case. Now, defendant says that that's taken out of context, that has something to do with the parole commission or with whoever considers this after the trial court. But I would implore the court to go back and read that paragraph in Young. It very clearly says, because of all of these provisions, and in that paragraph it talks about all the requirements of the trial judge, because of all of these provisions, there's essentially unguided discretion. And so if that is true, then again, the only thing that should be worried about here is if this is arbitrary. Did the judge flip a coin? Did the judge not look at the trial record? Did the judge go, I'm not going to exercise discretion? As this court well knows, there are those kinds of instances. For instance, during a trial, a jury asked to see part of the transcript. And of course, maybe it's hard to get the transcript, but we know from case law, if the judge says, no, you can't have the transcript, that's an abuse of discretion because the judge did not exercise discretion and said, no, I can't do it. If the judge says, in my discretion, I'm not getting you a transcript, it's fine. And so that's what we have here. We have an instance where the trial judge did everything that he needed to do, and there's no abuse of discretion. So defendant talks about some of these cases in which findings of fact are somehow impliedly required, and all of those cases are civil cases. I don't know of any criminal cases that have said that. And again, back to the Chief Judge's point, I can see that we need to know at least whether the court did what it was supposed to do and look at the trial record, but there's nothing further that is required. And certainly, there's no notice required. There's no opportunity to be heard required. The Supreme Court in Young said that again. Those things are not required under this statute. So as long as we have a finding like we have here showing compliance, then there is no error here. The recommendation goes on to the Parole Commission, and they do with it what they want to do. This is certainly not a model of clarity in this statute. But this much is clear. There's nothing that says there's a right to appeal, and there's nothing that says that all of these findings of fact have to be made. All that has to be done is what the trial court did here.
Let me ask you this, it's just way hypothetical, but you say flip a coin, or let's say this judge just thought, I just think men are more dangerous than women. And so in this judge's mind, yeah, I reviewed the record, but what was in his mind was, and I think men are more, the reason he did it was I just think men are more dangerous than women, so I never grant this for men, I will for women. But we don't know that's what he was thinking. Should we send it back and ask him, what were you thinking? So if he did make that, if that really was his reasoning, I would think that you would concede that would be an abuse of discretion.
That sounds arbitrary, but my question is, would we really get a finding of fact that said that from the trial judge?
I hope not.
I really,
But can we conduct, well, answer the question, because your friend here would say, well, how can we know what he was thinking? I mean, that's why we need findings to know what he was thinking.
We can never know exactly what a judge is thinking. The
Unless
judge can put, the judge.
Unless he tells us.
Unless he tells us, unless there's some way of knowing it. But there's nothing again here that requires any findings beyond the fact that he did what was asked, and that is to review the trial record and make a recommendation. I think one of the things that was said by defendant in the argument seemed to be that the trial judge could alter the sentence so that it was now life with the possibility of parole and then send that to the Parole Commission. That is not permitted by the statute. That is not at all what the trial judge can do. The trial judge can either recommend alteration or commutation. And that's all. The trial judge doesn't get to decide anything. It's simply a recommendation. So the trial judge can't say, well, I'm going to turn his sentence into life with the possibility of parole, and then I'm going to send it to the parole board. Can't do that. Now, he could say, I think that this sentence should be altered, and can send that to the parole board. But there's a difference there, and I want to be sure to make that clear. Unless the court has any other questions, the state would ask that this appeal be dismissed and that this court, if it does treat this as a petition for certiorari, deny that petition for writ certiorari because there is no merit to the appeal. The trial court here did everything that was required of the trial court to do. There's been no showing of any arbitrariness that would mean that there was an abuse of discretion in this case.
I do have a question. When can defendant seek another review? Is it 2 years from the date of the last order, or the date 2 years from the date this appeal is resolved, or 2 years from when?
That, like many things in the statute, is not clear. The judge here said 2 years from when he made this recommendation, so it would be January of 2025. I believe that's correct, what he said. But again, whatever it is, if this court says that there's a right to appeal, then potentially there are 200 of these appeals that are coming every 2 years, because that's when the review occurs. And part of this, again, is that defendant wants this to be something even more than parole, in that these are defendants who were sentenced to life without parole, and as defendant stated, in an apparent attempt to avoid the harshness of that, to mitigate the harshness of that, 15A1380.5 was implemented. But our Supreme Court already answered the question that this is not tantamount to parole. This is something less, not only is this less than clemency, it's less than parole. And so this is in compliance with the statute, and defendant should have nothing more. So if the court does not have any other questions, the state would respectfully ask that you that you dismiss the appeal, and in the alternative, if the appeal is not dismissed, affirm the trial court's order.
Well, if we have 199 more of these coming our way, wouldn't we want to clear up the water now if it's so muddy with all of this unguided discretion?
Certainly, that could be a reason. That could be a reason to grant certiorari, is to clear up what is expected in the future. If there are 200 of these are going to be coming every 2 years, maybe it is important to know how much the trial court has to do. So I think that is a good point in that regard. But again, if this court would do that, it should make it clear that there's not a right to appeal here, that defendants should have to file cert petitions in these cases. And when you think about it, as far as the final judgment part of this, in 7A27, there are plenty of post-conviction orders that are entered that are clearly not appealable.
But we're not even talking about an order. You just brought to our attention or reminded us it's less than parole. It's basically a recommendation or not. So what's the harm in clearing it up so that judges, trial judges from here on out know we're looking for these things when 199 of these requests come. Clean up your findings of fact and put it in there what you considered so we can move on.
I don't think there's any harm in that whatsoever. I don't believe in this case there's any harm in that. But after you clear that up, I don't see any reason from that point on to entertain appeals unless there is something that would indicate in a petition for certiorari.
It may not even be an appeal if we have it on record now. This is what is required, findings of fact from what you reviewed. And then folks may not even appeal it, even if they have the right to, those 199 people coming behind this case. And the judges who will now hear or review their request. We now know, as a finding of fact, it's not enough just to put a sentence, I reviewed the record. Based upon my review of the record, I find the following. That sends a signal to the 199 folks who may come up behind this particular case and say, well, the judge already made those sufficient findings of fact. I don't have a shot. I'm just not going to appeal it. It's a recommendation.
That's correct. That would head off a lot of appeals. But back to the premise here that there needs to be some further findings of fact. The state would disagree with that. The state says or asserts that the findings that were made here are all that is needed. And if this court said that, as long as the trial court makes it clear that it has complied with the statute and reviewed the trial record, then that is all that is needed, then that would be a perfect thing to say, and we wouldn't have, presumably, a lot of appeals.
Thank you.
Okay. Thank you.
Thank you. He's still got about 10 minutes, so.
May it please the court. I'd like to start with State versus Brown, which I addressed in my reply brief. I do not believe that State versus Brown is binding when it comes to the definition of final judgment, because our Supreme Court has defined a final judgment under Chapter 7A as one which disposes of the cause as to all parties, leaving nothing behind to be judicially determined between them in the trial court, not using the definition from 15A 101, which, as explained in the reply brief, only applies to statutes within 15A. So I would contend, for the reasons stated in the reply brief, that State versus Brown is not determinative here, and this court can determine that this is a final judgment and that Mr. Dawson has a right to appeal.
Why wouldn't State v. Young be determinative then? If you don't agree with Brown, why not use Young?
State versus Young is a completely different procedural posture than what we have here, and why the state contends that everything it has to say about 1380.5 is binding, I simply don't think that's the case. State versus Young involved a juvenile life without parole sentence, and the state was contending in Young, quite contrary to what's contending here, that 15A 1380.5 was so important and gave such a chance for review that it altered the very nature of a life without parole sentence to make it something less, so that sentencing was not required under the United States Supreme Court decision in Miller. And the North Carolina Supreme Court was addressing whether or not the defendant was entitled to resentencing because they had a life without parole sentence, or whether, as the state contended, they had something less. And it is in that context that the North Carolina Supreme Court said that North Carolina General Statute 1380.5 provided no rights, no procedure. It had no guarantees. And it also was saying all that in the absence of an actual case before it addressing a review under 1380.5. So I don't think that what the Supreme Court had to say about the procedure and the discretion afforded to the judge in Young has any bearing now, when this court is actually faced with a review under 15A 1380.5, where the judge did not make findings and did not explain his reasoning, and did not allow for this court to have anything to review, really. As Chief Judge pointed out, it's very difficult to review something when there's no findings and no reasoning.
I'm glad you stop right here with the findings. How far back in review of the record would be sufficient, as your argument is, for the court to determine whether or not it was arbitrary? I mean, initially you said, well, what if the judge considered he's no longer a threat? This is post-conviction or post-sentencing. But how far back into the weeds of the record would you expect a judge to make findings of fact?
I would expect that a judge would make sufficient findings to show that he reviewed the trial record as required by the statute.
I mean, are you talking about the instructions to the jury? Were they sufficient? Were they inadequate? Are you talking about reviewing what the witness said on the stand, whether or not they found it? So you see what I'm saying? It just opens up a can of worms of how far back to go.
I do understand that it does open a can of worms, and again, I will say the statute is not a model of clarity. I don't think that the judge has to go back and find legal error. I don't think the purpose of this review is a second appeal. I think that the purpose of this is to guide appropriate cases towards clemency. So it may be in some cases that the instructions are relevant to what the judge considers. Here, the instructions included an instruction on self-defense. The defendant presented a defense. That is a kind of factual finding I think might be important, depending on how the judge rules. So I don't know that I can say the judge has to make findings regarding X, Y, and Z in order for it to be sufficient. I think it's like all factual findings, it really depends on the case and the circumstances. And when this court is looking at an abuse of discretion, it's looking at the circumstances of that particular case to determine if the judge acted arbitrarily or made a reasoned decision. So I really think it just depends on the nature of the case.
I'm just trying to figure out, how are you not retrying the facts and the evidence in the case without
Right, I don't think that the purpose of this and what the judge is just making a recommendation. I admit I misspoke earlier when I said the trial judge could alter. I meant could recommend an alteration to include parole. But I think the judge here is in a unique position of having presided over murder trials, where most of our governors haven't. And when they are looking at something from clemency, they're looking at it from a very different perspective. A judge could sentence a defendant to life without parole and believe it is unfair, given the circumstances, but still do that because that's what the law requires of him. But in some cases, maybe the judge would look at it and say, compared to other murder cases, this one did strike me, that life without parole is a particularly harsh sentence. I don't know.
Well, I mean,
I think it's...
in this case, just as an example, hypothetical, if the judge said, well, I looked at the record and I saw the man was shot in the back and the defendant used the N-word, and for all those reasons, I don't recommend that he be considered. That's a finding of fact sufficient for you to get past this point?
I think that's a finding of fact sufficient to justify a judge's reason, yes.
Thank you.
I guess the finding you're looking for is, I mean, the judge says all the things that he did, but we don't know the why, is what you're saying, is like,
Yes.
if he had simply said, and even if he's a great guy and has bad health, given the nature of the crime, in my discretion, I deny. But we don't know if that's the why, is what you're saying. At least the judge needs to put something like that down, because we don't know if it's because my experience with men is they're more violent and therefore blah. We don't know, so we can't conduct meaningful review. It sounds like what you're arguing. You're not asking for, you're not saying that it needs to make extensive findings, just to say the why. Simply say, because of the nature of the crime, in my discretion, and that wouldn't be, you know, people can disagree about that, but your argument here is that we just don't know the.
Yes, Your Honor, that is my argument. We just don't know why, and there has to be some indication of why. And I would say the defendant is not asking for more than parole or more than clemency. I think the state underestimates what's required in those proceedings. The United States Supreme Court has said in clemency proceedings, a defendant is entitled to notice an opportunity, the opportunity to be heard. The Fourth Circuit has said in parole cases the defendant's entitled to the reason for a denial. That's all I'm asking for here, is a why, so that the defendant knows and so that there can be meaning to this review that's going to occur every 2 years. And to be clear, that review is only going to occur every 2 years if a recommendation isn't made that results in the alteration of the defendant's sentence. If a recommendation is made to the governor that the sentence be changed to life with parole, and the sentence is changed to life with parole, at that point, there's no more review under this statute. Even if the defendant is never paroled, he would no longer have a right to review under this statute because his sentence has been altered in accordance with it. So the 199, that is the number, 200, including Mr. Dawson, that the School of Government does cite in its post, but some of those defendants have received recommendations that their sentence be altered. So this court is not suddenly going to be flooded with 200 defendants because some of them aren't going to appeal, some of them are going to have their sentences altered. So I don't think that number is a reason for this court not to recognize a right to appeal in this case or in any of these other cases. So for the reasons stated in the briefs and here, again, would ask that this court find that Mr. Dawson has a right to appeal from this recommendation, and as this court stated, if necessary, invoke cert to review these questions, because we do have other defendants that could, and other trial courts that can benefit from guidance from this court. And I would ask that this court does vacate Judge Wiley's recommendation because the findings are insufficient and remand for a new review. Thank you.
Thank you for your arguments. They're great arguments, and we will take it under advisement. Madam Clerk.
So you're not doing this all the time anymore. right?
No, I haven't been doing this all the time for like 6 years.
I'm surprised to see your name.
Yeah, I just, it's my moonlighting job, and somehow they like to have me come over and argue.